um, I'm involved fully, if I can put it that way, or to stress it 150% in working on the content that is there in the courses that Law Seco has. So, like, I'm actively involved in curating the content, right? So, we're going to be talking today about shareholders agreements, which is an important part of our course in the in M&A. We have a diploma in M&A, and we teach shareholders agreements extensively in that course, because it's one of the main work that corporate or M&A lawyers will get to do. It is something where maximum corporate lawyers will make money from or earn from. And we'll talk about what are the kind of ranges, or what is the money people can charge when they are drafting shareholders agreements. But right now, like, let us look at uh, how to draft it. So what is the work that will be involved when you are actually drafting a shareholders agreement? Okay, ready to get into it? Say yes. Ready to get into shareholders agreements? Ready to get into it? Yeah, brilliant. Thank you so much. Let's get on to the shareholders agreements. Okay, very good. People, I like people who, when you are enthusiastic and when you really want to do some things, that's exactly when you are able to, like, get the maximum hang of it, because you're involved, you're interested, you're keen on that, right? Okay, so let's get into, like, the parts of the shareholders agreements. So what is the purpose of the shareholders agreements? I think some extent we discussed this yesterday in the webinar, but there are many people who are attending for the first time. So can someone say what's the purpose? Why are shareholders agreements entered into at the time of an investment transaction? Why do we enter into shareholders agreements? Anyone has? Thank you so much, Urvashi. That's so good to hear. Right. What's the purpose of shareholders agreement? So why do we enter into? Okay, at the time of an investment transaction, why are shareholders agreements entered into? Come on, at least the people who were there yesterday, say something. Say whatever you know about it. To enter into terms of investment, agree terms of investment. Okay, to an extent, yes. What else? Let the shareholders be clear about internal regulation to be followed by each of the shareholders. Okay. First right of refusal. Yeah, we'll come to that, Kaustubh. Okay. To define the rights of the parties involved, isn't it? Rights and protecting interests of shareholders. Yes, that's also a concern at one point. If you are putting money into a company as an investor, right, you want certain things, you want to ensure certain things so that your money doesn't go down the drain, right, and it gives you some returns. It's used for the purpose that the founders have said they're going to use it for. Okay, protecting both the business and shareholders, to define the terms and conditions governing relationships inter se. Wow, that's like a textbook definition. Does this apply to both public limited and private limited companies? It applies to any investment transaction, whether it is public, whether it is private. Yeah, it applies to any investment transaction. See, the logic or the purpose of shareholders agreement is that when someone else is entering into a company, right? Someone else is investing in a company. Yeah, it can work as a safeguard as well. So assume that, let's assume that someone has started a business, like you and your friend have started a business. Okay, and slowly you are developing customers, you are selling products, you are providing services, you are generating income. Okay, but now you believe that you want to, let's say, set up a new department, you want to start a new product, maybe you want to improve upon existing product, you want to expand your market, okay, and you find that there's a lot of demand that's already there, but you are not able to meet that, you're not able to cater to that, and you have found that there is someone else, some more demand that can be there if we reach out to them, but right now you aren't able to cater even to existing demand. So how are you going to go and reach out to that market? Okay. So at that point of time, you look for investment, you look for people who can put money into the company, and you also look for guidance. They can also help you to manage the company, maybe put more people on the ground who will be able to manage the supply and cater to the demand. Okay. Existing as well as more demand that can arise. So now what do you do? Uh, yeah. So Satvik, we have only just begun, so don't worry about it. We're only talking of, what happens logically in a business. So you're going to be looking about investment, looking for investment at that point of time. Now, since you and your friends were only there at the beginning and you were like, just working on the basis of a mutual understanding, you had things inside your constitution documents where you were not very you didn't want to define things very very strictly because you trust each other, right? So like you kind of put down the standard regulations for a company to deal with, and you started the business that way. But now someone else who is external is going to invest and put money into the business. So they will want very, very well defined terms. They will want a clear idea of what is going to happen with their money, how you are going to use it, how you are going to provide them information, what is the kind of intervention you will allow from them, when will you ask them before doing certain things. All of these things they will want because they are coming into the company, they are investing it, and they don't know you. Okay, they just believe in your idea, they believe that if they put the money they're going to get good returns. So they want everything very clearly defined and written down. Okay, and that's why you enter into shareholders agreements, so that it becomes very clear what are their rights when they are putting in the money, what are your rights when you are running the business. Okay, so that is what the shareholders agreement serve. Now Hasnain is a question, whether SHAs are executed at the time when the company is incorporated. No, it is executed at a time when you are taking in an investment. Who are the parties to the shareholders agreements? We're going to come to them. That's the next slide. Okay, so this is what the purpose is. Okay, so there has to be a very clear definition of what the two sides will really do. Now there may be parties which are more, but the sides are basically two: the founders and the investors. Okay, let's think of it like that. Now who are the parties to the shareholders agreements? Okay, so there can be one or more investors who are independent of each other. There can be people who are more than one people who are investing money into the company. Okay, and they are not any of the founders or family or any of them. Okay, so those investors will all be parties to the shareholders agreement. And of course you will have the founders or the promoters. Okay, so you can have people being defined as promoters in the shareholders agreement also. So those are the two sides that will be there. Okay, now number of parties can be more. As I said, there can be more investors, there can be more than one founders. Okay, and the company itself will also be a signatory to the shareholders agreement. Okay, why? Because the company also has to confirm certain things. It is required that the constitution documents of the company will be changed. Okay, so company will also be made a party to the shareholders agreement. So you will have the founders, you will have the investors, and you will have the company itself who is a party to the shareholders agreement. Does that answer your question, Hasnain? Yeah. So these are the three parties, these are the three sides that are there. Okay, now number of parties, like I said, will depend upon if there are more than one investors, More than one founders. What are the commercial intentions of the parties to the shareholders agreement? Okay, now think from both the sides. Okay, so what will the founders want? If you and your friend are running a business and you are taking an investment from someone, what will you want? Okay, what is your intention? What will you want? Think very logically and commercially. What will you want when you are taking somebody's money? You have told them you're going to grow the business. Okay, more investment, expansion of business. That's what you're going to use for. But in a term of investment, what will you want from the founder's side? Return on investment, the investor will want. What will the founder want? What will the founder want? The investor will want return naturally. Growth, okay, but growth is not something that you're going to put. That's what you will create. Increase in share value also you will create. Profit. Okay, let me put this in a better term. Vis-a-vis the investor, what would you be looking for? What will you be looking for vis-a-vis the investor? What would you be looking for from the investor? Stability, won't leave in between. Okay, that's one of the things. Okay, they're not going to go and sell their shares to someone else. That's something maybe that you want. Vis-a-vis the investor, you will want that they don't come and sit on my head and tell me what to do. Okay, because they have given me the money, they don't start to rule everything and they don't start to dictate everything. Okay, and they don't tell me how to run my business, and I don't dilute a lot of my ownership in their favor. Okay, this can be the founders' expectations vis-a-vis the investors, right? Control, yeah. So it's not that you want to control, but you don't want to cede control in favor of the investor. You don't want them coming in and sitting in on your head and then telling them that no, you must do like this, you must do like this. You want flexibility to run your own business. Okay, you may be providing information to them, you may be providing returns to them, but you want certain degree of flexibility to run your own business, right? So that is the interest of the founders that you have to take care of. Secondly, someone said they should not go and sell to a third person. Now you trust this investor, okay, and you trust that they are going to even make the benefit of their expertise and everything available to you. Now, if they just dump their shares in favor of a third person who's going to be completely unacceptable to you, you don't want that. Okay, so you want them to stay. As a founder, you want these guys to be there. Okay, you want their money to be there, and you don't want them sitting on your head also and telling you what to do. Okay, so this is the intention basically of the founder. They want also a good degree of flexibility in running the business. Okay, versus the investor. What's the intention of the investor? Kunjan, please put your questions in the chat right now. So, what is the expectation of the investor? Investor definitely wants a return on the investment, and investor wants the capital to appreciate. Okay, and investor also wants the ability to exit. In fact, two most important intentions of any investor are capital appreciation and ability to exit. Okay, just think of this. You are holding shares of a company which is listed on the stock exchange. Now you want to go and sell it. There are people there who will buy it. Okay, because it's a listed company, its shares are being bought and sold over the exchange. But you hold the shares of an unlisted company, who will buy it? You have to first go and look for people who are willing to buy it. You have to convince them that this is the worth of these shares, because there is no price that they can see. On the stock exchange, they can see the price. Okay, that this is the price that at which it is trading, so I have to buy at that price. Okay, but in an unlisted company, who is going to buy that? So you have to think that who will buy my shares. They'll be concerned about whether they are going to be able to exit the investment and at what point. Okay, so this is something, because what is the point of holding an investment, its value increasing, but you not being able to sell it? At certain point of time, you have to be able to sell it and actually encash the profits, right? So you can't just sit on it and book paper profits continuously when the price is increasing. Okay, someone has some comments on this. High return within a specified period. Yes, investor wants that. Okay, so they want that. They want, like, a high capital appreciation and the ability to exit. Dividend is a very less concern for the investor, because it doesn't turn out to be so much as the capital appreciation. Capital appreciation can go into huge amount of multiples. Like I was telling yesterday, if you have a 50 rupees share and you may be able to sell it at 500 if the company goes for an IPO, and, like, the shares are then listed. So it can be a lot of returns. Dividend will not be so much. How many of you have seen dividends being received in a year? It will be like, even good companies, it will be 2000, 3000, things like that. Okay, so per share, like, you receive some dividend, that's what you get. So it's not so much of an amount. Capital appreciation, Hasnain, is when your share of 50 rupees now becomes of 100 rupees, 150 rupees, 200 rupees. Okay, so your investment in the capital is appreciating in value. That's what it is. Yes, Gunjan. Gunjan, you can put it down in the chat, please. You can put your questions down in the chat. Whether SHAs have overriding effect, we'll talk about that. What about confidentiality clause then? If we share everything to investor, you are not going to share everything to investor. Okay. It usually happens in listed companies. In fact, it happens more in unlisted companies. But the thing is, people will not be able to see the value until the unlisted company actually goes for a valuation. Okay, because their share is not, their price is not out there for you to see. Okay, lots of questions on this. Guys, let's proceed. We'll come to the questions. Can a lawyer working on SHA ask the founder to issue some shares to him or her? If you want to invest in, if that's when you are acting as an investor. Okay, so I don't think there is anything that is stopping you from doing that. In fact, there, just think of this thing. If an investor is a lawyer, or for that matter, if the promoter is a lawyer, then they know the terms, right? They know how to work on this. So this is a main question now. We're getting core into the work. Okay, we are talking about what is the work you're going to be doing when you're drafting the shareholders agreement. So let's focus on that. Okay. Future group versus Amazon, will come to that. Let's not get into the case. Okay. So now, how do you start to draft shareholders agreements? How do you draft it? Okay. What do you do and what do you need in order to be able to draft a shareholders agreement? Let's come to that. So you need three things. Okay. What are the three things that you need? First, you find a good template. Okay, and there are people who believe in drafting things from scratch. Okay, although that is not a very good idea, and I'll tell you why. Because certain things like a title, like, the names of parties, like recitals, all of these things can turn out to be same. So why do you want to type and why do you want to draft that all from the scratch, right from the beginning? You can find a good template. This can be available on the internet. If you see, even there will be some companies who will have filed SHAs with the US SEC. Even in that, you can get good templates. Okay, sometimes. So you find a good template that is there. Okay. Next, what you need to do is you have to get the term sheet. We discussed yesterday about what the term sheet is. It is basically a document where both the parties, the founders and the investors, have agreed major terms of the investment transaction and they have signed and accepted it. Okay, so all of that terms will now have to be put into the shareholders agreement. So you need the term sheet in order to be able to draft a shareholders agreement. You have to know this. Okay, and instructions from your client. Okay, if your client has very specific instructions on certain things, then you need instructions from the client. You have to take care of that. Okay, and instructions can be on things like what is going to be the valuation at the time of conversion of instruments, things like this. Okay, so instructions from your client is something that you need to have all of these three things open and there with you when you are drafting. Okay, so now when you start to draft the shareholders agreement, what do? You just open up the template and start editing. How many of think you do that? How many of you think that we should do that? Open up the template and start editing. How many of you think you should do that? Open the template and start editing. What is the way when you have all of these three things? What do? Gunjan, is it not possible for you to put your question down in the chat, dear? You do a SWOT analysis? No. Go through the term sheet first and instructions of the client. So when you are drafting any kind of contract, okay, the best idea is not to start editing the template. Okay, you shouldn't do that. You should not work on editing the template. Open a blank document, take the clauses that you need from the template and paste it into that document. Okay, what if we do not have a template? Highly unlikely. You will anyway, like it may not be a good, but you will definitely find SHA template in the on the internet. Okay, somewhere or the other you will find it. It may not be a great template, but you will find it. Okay, please don't ask questions which are completely not connected with the topic. Okay, let's deal with this and then we'll come to other questions. Okay, so how do you draft it? Like, you say you don't find a draft. Okay, you will definitely find drafts that are there on the internet. We have, if you look at the M&A course, like we try to, and because this is such a critical agreement that is there to an investment transaction, we have something like 4 to 5 drafts of SHAs in our course. We keep 5, like, for this specific agreement as such. We keep this with us. Okay, but you can find it on the internet. There are drafts there on the internet for shareholders agreement. Definitely there are. Okay. So now what you do is you open a document and you start relevant template. No, it's not necessarily US law. You have even Indian templates. You have it. Okay, definitely you have that. You can find and search a little bit more. You have it on the internet. But the way what I'm saying is that when you're drafting it, you open a blank document and you start to copy those terms which are relevant for you into your document. Okay, now there may be specific clauses which you don't find in the template. So you can look for instructions, so you can look for those clauses when you're looking for, you can search for those clauses and you can find them if you don't find it in the template that you have at hand. But there are certain things which are common to agreements, and these are common to agreements the world over. Every agreement will have a title, every agreement will have a parties clause, every agreement will have recitals. Okay, and it doesn't matter whether it is Indian law or US law, these kinds of things will be there in, like, the agreements. And this is for any agreement. Forget about shareholders agreement. These things will be there in any agreements. Okay. So you look at, like, getting those clauses from the template into your document, and then you start working onwards on the different parts. Are SHAs statutorily required? I have not known until now any investment transaction which had not involved an SHA. Okay, and if you are a lawyer, you should definitely advise your client to have an SHA. Otherwise, yeah, there can be people who are investing things like, without any kind of SHAs. There will be people who are making investment in companies even in cash. In India, this is possible. I'm not saying that, like, it's these are not really legal or the right ways to do things, but it might be happening. Okay, there'll be things where people put things in cash. What kind of agreements do you enter into in that cases? But in that case, people know that they stand a chance of losing everything. Okay, unless they have such amount of trust in the person in whom they are making investments, that you don't enter into a written agreement. Definitely you will enter into a written agreement, and you want something on record to do that, and especially above certain amounts. Okay, if the amounts are large, okay, anybody will want things to be written and crystallized. Okay. Okay. So parts of the shareholders agreement. So like I said, you start to get all of these three things, and then you start to build it. Title parties recitals, like I said, this will be there not only in the shareholders agreement, it will be in any agreement. Okay, so you will find this in any agreement that's there. And, like, this is something that you will like to you will have you have right at the beginning. Okay, so the title is, of course, a shareholders agreement. Then shareholders agreement can be combined or joined with share purchase or share subscription agreements also. So then your title will be share purchase and shareholders agreement, or share subscription and shareholders agreement, or if it's a separate one itself, you will have shareholders agreement as the title. Okay. Parties, I already told you who the parties are. Okay, it will be the founders, the investors, and the company. These are the usual parties. Okay. Recitals. What are recitals? Basic, everyone is learn contract law in the colleges. What are recitals? Bhavika is saying not audible. Am I audible to other people? What are recitals? Background of the parties. Yeah. Okay. What are recitals? Competition to contract. What is that? Terms of contract. No. Recitals are background to the transaction. Not, well, it will involve a bit of background to the parties also, and also background to the transaction. Okay. Introductory statement. Yeah. So why are the parties? What happened before? What is the story before that now the parties are agreeing to enter into this transaction? Basic things of parties. Well, yeah. So a brief background of the parties, okay, and a brief background to the transaction. Okay, so that's what will be there in the recitals. Okay, representations and warranties. Okay, so what will, again, please, let's not get into the discussion on what is the difference between a representation and a warranty. That's something that's very basic to contract law and is not specific to a shareholders agreement. Okay, so let's not get into that discussion, otherwise we will digress and we will leave all of the rest of the things. But what are the standard representations and warranties that you can find in a shareholders agreement? Okay, and these are also some representations of warranties that you find in most contracts as well. Okay, these are something that you will find in many contracts. Basically, this is an assurance, okay, by the founders and to some extent by the investors, that they are able to enter into this contract and nobody is stopping them. Okay, no law or any previous contract is stopping either of the parties to enter into this contract. And if I enter into this contract, it's not going to result into the contravention of any law or breach of any contract. both of the parties are validly existing entities. Okay, so like the company is validly existing. If a company is investing, the company is an investor, then that investor company is also validly existing. All of those things will be confirmed. And again, where there are companies involved, you will also confirm that there is no insolvency or winding up proceeding which has been initiated against each of the entities. Okay, so not only that they are validly existing on today, nobody has started or initiated a winding up proceeding, okay, against either of the entities. These are the kinds of basic representations. Okay, there can be other representations uh, in the transaction, depending. For example, if a company is highly IP based, then they will confirm that they own the IP. They will also confirm that other than the litigation and everything that is informed to the investor, there is nothing more than that. So there are no litigations, there is nothing which has not been informed to the investors. These kind of representations will always be there in the shareholders agreement. Okay. Conditions precedent. How are warranties different from indemnities? Like I said, Aman, let's not get into the basics of contracts. Otherwise, we will just digress from the topic of shareholders agreements. Okay, these are the things that are applicable to any contract, any contract. It's not specific to a shareholders agreement. Okay, but warranty is something that you are confirming that, whatever you are providing or your business is valid. Like, you are confirming something about the future. And indemnity is that if something wrong happens, then I compensate you for the loss. Okay, if something is not as I am saying, then I will compensate you for the loss. That's the difference between the two things, basically. Okay, so conditions precedent. What is conditions precedent? If these things have not happened, then the contract will fall apart. It will not become effective. Okay, if you have not done this, then it will not become effective. So the obligations of the parties will not kick in. The investor will not give you the money. Okay, unless these things are there. These are precedent conditions. You need to complete this, and you need to confirm to the investor that this is actually met with, okay, before for the investor to give you the money. So what are the basic conditions precedent? I'm not going into and listing everything there is, because otherwise it will be like, each of the clauses is capable of taking a whole session. Each clause is capable of taking a whole session. Okay, so I'm not going to go into all the details of that, because otherwise I won't be able to discuss the remaining things with you. Okay, so conditions precedent: transaction authorized and documents duly executed. Naturally, if you are not completing, if you are not signing the documents, okay, then how will the contract kick in? How will it take effect? So it's a mandatory condition that you have signed it for the investor to give you money, right? Copy of the approval. So your company has provision that this transaction requires the approval of the board, and it requires approval of the shareholders also. So now, unless you show the investor that, look, I've got the approval for the transaction, is not going to give you the money. Okay. So again, you have to give the copy of the resolutions that are passed by the board, resolutions that are passed by the shareholders. Okay. And that's a condition precedent that you have to provide that. Your capital has to support the transaction in case of a subscription. So if there are new shares that are getting created, okay, there is an increase in the number of share. So now whatever you are eligible to issue as authorized capital has to accommodate that, right? Let's say the maximum capital that you can issue according to your memorandum is 10 lakhs. And now you are going to the investor and asking them to invest 1 crore. So now your capital does not support it. So you can't do it. First, you have to increase your capital to 1 crore 10 lakhs and then go and ask 1 crore. Right? So your capital has to support the transaction for them to give you the money. Valuation conducted. Naturally, like they are giving you the money on the basis of a certain valuation that is conducted for your company. Okay, so they will say that I am giving you 1 crore and I will take this many shares. But in order to decide how many shares will be given to them, you have to have a valuation that is attached to each share. Otherwise, how will you determine that? So that has to be done in order for them to give you the money so that they know what is the number of shares that they are going to get for the money, right? These are all things that you have to do before. Okay, otherwise the investor is not going to give you the money. Okay, completion. So when all of those conditions are met and the investor has given you money, then what are you going to do? So on the completion, the investor will give the money. That should have been the first point here. Okay, investor will give the money, send the money, transfer the money to the company or the promoters depending upon the agreement. Then those shares have to be allotted or transferred to them, and they have to be given the share certificates, or share certificates have to be transferred to them. If the holding is in electronic mode, then their electronic accounts have to be credited with the number of shares, and your registers have to be updated with the entries for the transfer or the allotment. Okay, on completion or closing, okay, it's also called closing. This is what will happen. Okay, and I am speaking in a very rudimentary language, that someone will give you the money and then you allot the shares, you issue the share certificates, and you make the entry in the registers. Okay, conditions subsequent. Now, after all of that is completed, what are you supposed to do? Okay, and this is something, like I was saying yesterday, people kind of miss out on, because there are deadlines for filing on allotment, there are deadlines for filing on alteration of constitution documents. If a non-resident is investing, then there are deadlines for filing with the RBI. All of that has to be completed after the money is received, after the shares have been allotted. You have to do this, right? You have to complete the necessary filing, and this will also be put into the shareholders agreement. Why? Because you don't want the company generating penalties. Okay, the investor has given you money to put into the business, not to pay to the registrar as penalty for default on filing. Okay, so you will be asked to do that in time. So what are the things that now the investor will ask, and also the things that you will want as a founder? Okay, so investors can ask this. They can ask for observers or nominees depending upon the amount. Sometimes, if the amount is very high, they can ask that they will appoint a director on the board, okay, who is called a nominee director, and that nominee will take care of the interest of the investors. Okay, otherwise, they will just appoint an observer. So, someone who is going to come and sit at the meetings and see what is happening there. They do not have a right to vote. Okay, so they will not decide how the decision at the board meeting goes, but they will just be there and they will see. Okay, so they can appoint observers or they can appoint nominees also. Every time the founders may not agree to the appointment of a nominee if the amount is not very huge. Okay, why? Because they don't want the nominee director to come in and decide everything that is happening in the company where the stake of the investor involved is relatively smaller. Okay, so they will say that nominate an observer so you can see what is happening and you can be informed about it, but you cannot change everything of the way we are doing the business. Okay, however, if the stake involved is very high, then, like, there will be a nominee director who is there on the board, and that person will be voting, okay, on how the decisions take place at the meeting. That's the difference between an observer and a nominee. Okay, superior voting rights. Okay, so in some cases what happens is that founders can have more rights even than investors. on a voting at the board meeting. Superior voting rights are not called differential voting rights. Those are two separate things, Jay. Okay. So this is more to do with the board meeting. Differential voting rights are more to do with the shareholders or the general meeting rights. Okay. Here we are talking about what is the voting that happens at a board meeting. Okay. And in the board meeting also there is voting that happens. Okay. So they, whoever has a higher vote will decide how the transaction goes. So sometimes investors will have a very much upper hand and founders will be desperate for investment. Then the investor can say that every vote that our director casts, it will actually be counted as two votes. On the other hand, if the founders have a really stunning business and they have got investors to invest into it, they are dictating the terms, then they will say that every vote that we cast will be considered as two votes. And this is at a board meeting, okay, not at a shareholders meeting. So this can be negotiated. Affirmative voting rights or reserved matters. So this is basically an investor protection measure. It is not like, to stress your dominance or something. Okay, so this is that if you are doing something very huge in the company, something that is going to impact the business of the company to a great degree, okay, then you will ask for a confirmation or a consent of the investor. Okay, because they may not agree to that. Their money is also involved, so they may not agree to that. Okay, so capital investment or borrowing. Okay, so let us say you are out of the 1 crore that you took, 90 lakhs you are putting into a plant. Okay, now that may be according to the plan, but after that again there are more money that you are putting into a plant. Okay, huge capital investments you are making. So now for that you will ask for the consent of the investor because they will think as to whether this is feasible or not. If you are going to borrow a large amount, okay, you have taken 1 crore of capital, and let's say you are going and taking a loan of 5 crores. So you are creating a liability for the company which is massive, which the investor may not agree with. Okay. So for huge borrowings or borrowings above a certain amount, also there will be provisions that you ask for the consent of the investor. Employing key managerial personnel, your CEO, CFO, COO. These are the people who are going to be running the business. So now if you're going to change them and you're going to bring in a new CEO, a new COO, the investor may not be very agreeable with that. Okay, so they will ask that you take their consent. What is affirmative voting? So you must ask for my affirmation, you must ask for my confirmation before you proceed with this business. Okay, so employing KMPs, amalgamation, merger, major acquisition. If you're going to do any of this, then of course you seek the consent. Budgets and business plans. Again, this can be above a certain amount. Okay, all founders will not agree that everything that they make as a plan for business or every budget the consent of the investors, but something that is above a particular amount, you should ask for. So that can be included in affirmative voting rights. ROFR or right of first refusal. Someone got onto this very much in the beginning. What is ROFR? Quickly, can someone tell me? Then we'll move to the next one, ROFO. What is ROFR? Right of first refusal. People have heard this right to refuse selling of shares. But what does that involve? Of the other party, yeah. So it's not right to refuse the selling of the shares. It is just to say that either of the parties must first sell the shares to the existing party. Subhash, what you are saying is preemptive. So we'll come to that. Okay, but let's say if the founders have certain number of shares, investors have certain number of shares, if any of them want to sell any of their shares, then first they have to offer it to the other party. Founders must offer it to the investors. Investors must offer it to the founders. And only when they refuse, then they can go and sell it to a third party. So that is right of first refusal. Okay. So you can, if you, they'll come to you first, and if you refuse, then they'll sell it to the third party. Okay. Then there is another one, right of first offer. So now what is the difference between that? Here also we are talking of offer. Here also we are talking of offer. Okay. What is the difference between ROFO? What happens in ROFO? Anyone has any clue of this? See, it's a very interesting, it's a little bit of an improvement over ROFR. How? Because just assume I am an investor, okay? I want to sell my shares to a third party. I have decided. I don't want to sell to you as the founder. I want to sell it to a third party. So what will I do? I will offer you at such a high price that you can't buy it. You will not buy it. I'll say that you buy my shares at this price. You will refuse because that price is too high. Okay. So now then I'll go and sell it to a third party at a lower price. Okay. So that is not allowed. In ROFO, what happens is that you have to offer first to the other party. Okay. And you sell it to a third party. And if nobody is willing to buy the shares during, like, a certain period at that price, then you have to come back and offer it to the previous party. Okay. At a lower price or at an adjusted price of whatever the other party offers. Okay. So you will have to down your price depending upon what an external party is willing to offer for the existing party. Okay. So let's say the shares, I'm just offering you shares which are actually worth 100 at 150 rupees. Okay. So now if I go and offer it to the third parties at 150 rupees, and someone outside actually quotes and says that I'm not going to buy at 150, but I will buy at 115. Okay. Then I have to come back and offer you at that price. And if you don't want to buy, then only I'll go and offer it to the third party. That is offer. That's based on an offer from a third party. That's why it's an offer based mechanism. It's not like, a refusal based mechanism where whatever price you offer, the other person has to take. Determining price of shares is also a challenge. Valuers appointed, yeah, they can give different figures exactly, which is why ROFO is an improvement, because when you offer it to a third party, you will come to know what is the price someone else is willing to pay in the market for your shares. Okay. You conduct a valuation, but you will come to know what is the fair market value for your shares, because you have offered it outside and someone else has come at this offer. Now that's the offer price that someone else has made. So you offer it at that price to the existing party. Okay. That's the right of first offer. Everybody clear of this difference? Everyone clear? Why ROFO is an improvement? There are only two yeses. What is the happening to the rest of the people? Why do I have to ask again, that too for lower price? Because very obviously that is not the price at which the other people are willing to buy in the market. Okay. So you have established a market price for your shares by offering it out in the market. Okay. Where other people bargained and said this is a lower price. So you kind of let in a market price setting mechanism, and then you offer to the existing people at a market price. That's why you have to offer again. Okay. Brilliant. Okay, let's move to the next one. Preemptive rights. This is what Subhash was saying, Subhash. So if there are any additional shares that are issued, you offer it first to the existing shareholders, and you let them take the additional shares first, okay, rather than going to a third party. That's what preemptive rights are. Okay. So new shares, any new shares that are issued, you offer it also to founders, offer it to investors, and if they take it, then it's okay. Otherwise, you issue it to external people. But first chance to the existing shareholders. Drag along, and this is a danger, and this is out of fashion. People don't have this in SHAs anymore. Okay, because it's a dangerous clause. What is drag along? Anyone who is a big investor, huge investor, and is calling the shots in the company can actually sell the company to a third party, and they can compel the other person who are there to sell their shares also. If I go somewhere out, I come out of the company and sell my stake to a third party, I can drag you with me and I can make you sell your shares. That's what a drag along clause is. Okay? Both the group of shareholders have to go together. No, I mean, if the thing is, the investor can pull you, they can drag you, make you, compel you to sell your shares. That's a drag. Okay? If the investor sells the shares to a third party, then they can compel the founders to sell their shares also. That is what a drag along clause is. Okay, and this was famously there in the Snapdeal agreement. Okay, it is uncommon because people have realized now that it's dangerous. Founders generally will not agree to that. Okay, tag along is a right but not an obligation. Okay, so in that, there is not a compulsion that you go mandatorily and compel someone to sell their shares, but there is a right. Okay, there is a right to the founder. Okay, so if the investor goes and sells their shares to someone else, okay, and the founder also believes that there is a good price which the third party is paying, so then the founder has the right to say that take me with you. Okay, tag me along with you. If you are selling, then make me also sell the shares, like get the other party to agree to buy my shares also. Okay, so that is a tag along, and this is something that is now generally found in the obligations, because this is kind of a minority protection measure, so everybody agrees to this. Okay. Anti-dilution, another stinger. So what happens is that it's true that any additional or new shares you offer, you have to first offer to the existing shareholders. But let's say the investor doesn't want to buy. Okay. Yes, Chetan, both of them can coexist. But people generally avoid drag along now. Anti-dilution, like I'm coming to that. So the investor, uh, if they have a right to buy any additional shares which the company issues, that's true. But let's assume that right now they don't want to put any more money in the company. So what will the founders do? They will give the shares to any new investor at a very, very low price compared to what the previous investor had paid. Okay. When that happens, the total valuation of the shares of the company will go down. Why? Because now you issued the shares to a new investor at a very less value. Okay, so there are more shares in the company and less money because you gave them at a very low price compared to the previous investor. Okay, as a result of that, what happens is that the previous investors' value of the shares will go down. So they don't want that. So what will they say? If you want to give shares to someone else at a low price, then you have to ensure that the value of my holding remains the same. So you have also to give me new shares, okay, so that the value of my holding doesn't go down. Okay, I'm holding shares at 100 rupees. I gave you 100 rupees for one shares. Now what you are doing is you are giving shares to people at 50 rupees. Okay, so now what will happen? The value of my holding will go down. Okay, because I put in 100 rupees for the same share, the other guy is getting two shares for that same price. So you have to give me shares enough to make my value equal to that same person. Like, to how it was before the transaction, before you invited someone else. That is what is an anti-dilution protection. I believe this can be a bit technical for people to understand. Uh, Utkarsh, you can't issue shares at a discount under the Companies Act. It's not possible. Yes, it can. It happened in Redbus, correct? Redbus founders had very low holding, 10-15%, something like that. But is anti-dilution making sense? If you give it to a new investor at a lower price, then my value of holding will reduce because I gave you more money for the shares. So you must give me more shares so that it remains the same that it was before you issued shares to someone else. Okay. So I'm holding one share at 100 rupees. You gave someone two shares for 100 rupees. Okay, so now the value of my share has also gone down. So you issue me one share, more share, so that the value of my holding remains also the same. Okay. If it's illegal to issue shares at a discount, uh, discount is a discount to the face value. Discount is not a discount in the premium amount. No shares are ever issued at face value, Kaustubh. Okay. So 10 rupees is the face value. The investor would have paid 100 rupees and you are offering the new investor 50 rupees. It's still more than the 10 rupees of face value. Okay. So it's not a discount to the valuation of the company. The valuation might have gone down at that point of time. Okay. Okay, let's move forward. Information covenants. This will also be there. Okay, because you always want that the investors should have appropriate information about the business of the company. Unless they get, so they will ask for a copy of the business plans. They will ask for a copy of the financial statements. They will ask for a copy of the auditor's report. They'll ask for director's report. All of these things they will ask. Okay. So information covenants, periodically they will ask for certain information about the business of the company, just to be kept informed and assured that their money are going in the right direction. Okay. Termination. So in a shareholders agreement, again, like any contract, there can be termination. So if there is a breach of a representation or warranty, there can be termination. Okay. The investor does not pay up the money on time, there can be termination. Okay. If the founders are doing certain things or not taking care of the affirmative covenants where they are supposed to ask the investors, there can be termination. There can be termination of the contract for a lot of different reasons. Okay. And all of these will be put down in the termination clause. Okay. Notices, governing law, and dispute resolution. This is standard for any contract. So if notice has to be given to anybody, then there will be an address and a name provided where you are supposed to give a notice, or there can also be a designation provided, if not name, where each of the parties are supposed to give notices to each other. Okay. Governing law and dispute resolution. Usually, this will be the founder's place, the investee entity's place. It will not be the investor's place because investors might even be spread over a lot of different places. Severability, again, it is like, a standard clause in any contract that if some clause becomes illegal for certain reasons, then that will be considered as taken off or severed, and the rest of the contract will hold good. Entire agreement counterparts. So, like it says that this is the entire agreement, that there is nothing remaining or to be added upon to this agreement. And it can be signed in counterparts, particularly in COVID times. You might want people to sign it at different places. They may be at different places. So, you might want them to sign at different places. So, it will be like one agreement and 2 or 3 signing pages. That is possible. Okay. Can we bifurcate between preemptive rights for new securities and existing securities? It's only for new, it's never for existing securities. Okay. Existing type, if you mean, yeah, you can bifurcate, but you will still have the preemptive rights for I think I dropped off for a second there. I'll come back to the slide. So confidentiality. Okay. And people will want to keep it confidential unless they are actually announcing it and declaring it. Now, some companies may want to announce boldly that, we got funding from this investor, so that, people come to know about the company and they start to buy products, avail services. They are backed by certain investors. That's what they will always say, right? Execution and signatures. I don't think there is anything to discuss in that. This is something where people kind of always uh, want to uh, want to be there. Could be organized on nuanced concepts. We'll come to them. We'll come to them, Aman. I'll take your questions after I'm done with that. Okay. So cap table or shareholding pattern, pre and post investment, you will want that, right? So you have right now the existing shareholders who are there, founders are there, they are holding this many percentages. Maybe some employees are holding uh, shares, so you have them as there. Maybe there is an ESOP pool in place. So you will have that ESOP pool is this many shares, maximum this much shares. Okay. And then after investment, who is going to be holding what percentage of shares? You will want that to be there. If there are convertible instruments involved, there will be one more table to say that what is going to happen after the conversion takes place. Assuming a certain rate of conversion, how will the shareholding pattern look after the conversion has taken place? Okay, all of these will be put as annexures to this agreement. Okay. What can you earn from drafting shareholders agreements? Okay, this is very important to know. Okay, see, just logically think, when shareholders agreements are entered into, they are entered into at a point in time where a company is receiving money from different people, and depending upon the amount of the money that they are going to be receiving, there will be certain degree of urgency and there will be a certain degree of cautiousness how much they want to spend on, like, drafting the shareholders agreements. Okay, usually this will go in higher ranges like 1 crore, 5 crore, 10 crore, 100 crores. There can be a big or huge amount that is getting invested. Okay, so people will want these documents which define the rights of the shareholders to be drafted very, very carefully, and they will want everything laid down properly. And because there is a requirement for these documents to be so particular, and also these will be time critical, you will want them to be drafted very fast. Okay, so because there is a requirement for speed and accuracy both at the same time in these documents, people are willing to pay the money. Okay, so even a fresher lawyer in the likes of Mumbai, if someone were drafting a shareholders agreement for a transaction, you can be charging easily 50,000. Okay, that can be kind of a beginning rate if you state that. And then as the amount grows or the level or the experience of people grows, there can be things like 1 lakh, 1.5 lakhs, 2 lakhs, 3 lakhs. There can be any amount depending upon, like, how senior or how how good the person is, how famous that lawyer is, and also, like, what is the amount of the transaction that is involved. Okay, but I am giving you a beginner rate. Even the likes of Mumbai, there can be things like 50,000 that you charge. 50, 60,000 that you charge for drafting a shareholders agreement. Okay. As normal, like someone who's an independent practitioner who's drafting this. Okay. 2.5 to 10 lakhs. Yes, as you grow, this will be there. What I am quoting is someone who's starting up, like, an independent person, and who's like, the startup is also new, investor is also new, and the lawyer is also new. Even then, you can charge this. Even then, you can charge 50. Okay, so complete beginner stage, it is this. And then, like, as it goes, it will increase. Okay. SHA or SHA with SP, SSA, usually it will be combined. How do we learn more and become expert and more trained at shareholders agreements? Now, if one agreement is going to give you 50,000 bucks, if you are really like, if you know how to draft it, if you know what you need to put in it and you know how to draft it, naturally you would want to know how to do that, right? So that's something that we do. That is exactly what Lawsico does. Okay, so we're gonna I can like share this with the people. So I'll just come out of the slide here and I will take you to this course here that we do. This is what we do, and it's one of the things that we do. I'm even going to show you one of the exercises that we do in this course, okay, for drafting shareholders agreements. So these are the objectives that you have at any M&A or other transactions. Okay. Yes, they should have full knowledge and negotiating powers. So how are you going to be knowing all of this? You have to be aware of all of the terms that I discussed yesterday, okay, in order to be able to draft this. So naturally, you have to understand it really thoroughly. You have to understand how to draft it, right? You have to know how to do that. Unless you know how to do the work, you are not going to get paid for it. Okay. So the name of that course people are asking is Diploma in M&A, Institutional Finance and Investment Laws. And this course is co-certified by MEPSC and Skill India. And shareholders agreements, by the way, is only one of the transactions that we do for this course. Okay, it's just one thing. And just think of that. This one thing has the ability to generate 50K for you if you know how to do that. Okay. So in addition to that, there are also rationales who understand the cost and steps in business transfer, asset purchase, okay, share acquisitions, mergers, how to choose the right transaction. Everyone might not want to take shares. They may just be interested in purchasing one of your assets or your business. So how do you do that? Okay. What are acqui-hire transactions and how are they carried out? Okay. Difference between venture capital and private equity investment. Many people are confused. What are angel investors? What are private equity investors? What are venture capital investors? Okay. All three people, and what do they do? Okay. If you are having a foreign investor, then how do you do about that? How do you go about that? And here we talk about an unlisted company. How do you do that in a listed company? Let's say someone wants to invest in a listed company in bulk, not just buying shares from the stock exchange. Then how do they do that? Okay. So pipe transactions, private investments in public equity. Okay. What are the tax impacts? Yesterday we were talking about angel tax. So what's the tax impact of investment transactions? Okay. And then due diligence again, no investor will put money unless the due diligence is carried out. So how does that happen? How is that carried out? How do you draft due diligence report if you're working from the side of the investor? Okay. All of this is covered in this diploma. And I want to show one exercise that is very relevant. Now, this is one of the exercises that we do in the course, and it's on drafting a shareholders agreement. Okay. So here we are going to talk like, this is about, uh, this is a situation that is given to you. And, there are some terms that you have to draft in the shareholders agreement. Okay. So we discussed that, observers. So how would you draft a clause that is related to observers? Okay. Veto rights in the case of a deadlock. If they have veto rights, how would you draft that clause? How will you draft a right of first refusal clause? How will you draft a tag along clause? How will you draft a clause where someone has the ability to nominate a director on the board? How will you draft clauses which are related to affirmative voting rights or reserved matters, which we discussed for the list that's given here? Okay. And last but not the least, how are you going to amend your constitution documents based on the investment transaction? This itself, this exercise can fetch you amending constitution documents, okay, based on that agreement. This can fetch you another 10-15K, okay, because it's an exercise to change your constitution documents based on the shareholders agreement, okay. Only difficulty comes when both group of shareholders are agreeable to hold 50% shares in equity capital. So you have to bring in, exactly. So you have to bring in something here. Look here. What happens in the case of a deadlock? Okay. We have said that there are veto rights in case of deadlock, or alternatively, there could be this provision that the chairman will have a casting vote. So, there won't be deadlock if there are 50% shareholders. So you look at this kinds of things. This is what we do. You actually draft this inside the course. Okay. And then if I come to what you can see in the course, there is a huge chapter on shareholders agreements. You might even be able to download that as a free material. If you click on the free material here, there are free materials here. Okay. Get free study material. So you click on the download, you will get free study material. I think this chapter is there, so you can have a look at how it looks like, what happens in shareholders agreements. Go download it and have a look at this chapter. Okay, and there are also templates for shareholders agreements in the course. Okay, this explains a lot of different things. Okay, so you can have a look at, download the material and you can see how it looks like. Okay, so there were some questions I would like to answer that before we end it. Yeah. So, what is the process of executing SHA? Does it need to be stamped? Does it need to be approved by NCLT? It doesn't need to be approved by NCLT. But it does need to be stamped because it's an agreement. It's a contract. Okay. Apart from drafting or vetting the SHA, are there other significant roles or functions of a lawyer in the SHA? You can advise on the terms that go into the SHA, the term sheet. Okay. So big deal. That's the big deal. You give an option to the promoter that they can choose different things. Okay, that's a significant value that you can create in helping to draft the term sheet. It seems that vital activities like statutory compliance, valuation, and due diligence can be better done by other professionals. Basically, what's in there for lawyers. So let me say that mostly the transaction of drafting a SHA is the one that is paid in the highest. Filing is not something that is paid very high. Okay, drafting the SHA and altering constitution documents. This is what is paid highest. So, and that's majorly done by lawyers. Okay, so I hope that answers. Is this available under master access? Yes, it is. SHA could be executed at any stage in the running company, or it has to be executed beforehand, before commencement of business. No, it will mostly be in a running company because the business has to make sense to the investor to invest in. In case of disputes, matters relating to SHA are referred to arbitration, which takes lengthy time to settle the disputes. Not necessarily. You can have mechanism that's there. Okay. How do you connect with me? Um, this is my email ID. Okay. Wait. This is my email ID. You can reach out to me on this, or else you can join this WhatsApp group here as well. I'm there in the WhatsApp group. Okay, you can reach out to me on that. I'll just put it in the chat. Okay, and also tomorrow, if people here are really lawyers and you're looking for, like, uh, getting clients or getting work, we have a webinar on how you can create or generate clients. This is something that, a lot of beginner lawyers will be looking for. So this is a workshop that's happening tomorrow, where you can actually join, and you can, like, get a strategy of how to generate or create clients. Okay, so that is something. Is it possible to get the certificate for the webinar? Yes, you meet the conditions, you can get the certificate for the webinars. Okay. I believe I have answered a lot of questions. If anything that is pending, you can reach in the WhatsApp group here. I've also put my email ID here. You can reach. Two investors sign one SHA agreement. Yes, they can. They can. There will be multiple investors who are there. Okay. Thank you so much, guys. Okay, quickly, how much value did you get out of the webinar? Marks out of 10 quickly before I leave. Come on. Marks out of 10 quickly before I leave, so I know how much did you get. Subhash says 8, 8, 10, 10, 9, 9, 9.5. Thank you. 11, thank you. Thank you so much, guys. Okay. And you can reach out to me if there are any questions. Have a look at the M&A course and download free materials. Okay, that much you can do without, like, giving anything. And I think the shareholders agreement chapter is there, so, like, you will get to learn a lot.